Hi, my name is Berjon, and I am VP of Data Governance at the New York Times. I am also closely involved in the TAG, the W3C's technical architecture group, work on privacy principles that are intended to guide a definition and an operation of privacy for the entire web. It's a great pleasure to be here today at the consent workshop, so let's jump right in. Consent is a rich and complex topic with a history that goes back over a century, especially for medical cases. But as of 4 or 5 years ago, it became particularly salient in human-computer interaction systems thanks to the GDPR that led to the adoption of consent across a huge swath of the web and created any number of issues that I'm sure you are all very much familiar with. And with that in mind, the question that brings us all together today, the question that has been animating conversations around consent on the internet for the past few years is, what the actual fuck happened with this train wreck that we have here? We have all used computers. We are all familiar with bad user interfaces. We've seen the GDPR consent dialogues and we've gotten used to them. But seriously, what is this thing? What is this catastrophic accumulation of mistakes? Just like the list of purposes is insanely long, but it keeps getting worse the closer you look. Now, what we have here is, for each purpose, two legal bases to choose from, both of which are in an indeterminate state for some reason. I don't know if this is supposed to represent maybe some kind of qubit system, entangled qubits, where you observe one and you might find something out about the other. I don't know what happens if you say no to consent and yes to legitimate interest. I don't know why there are only two. Why not pick all six? Why not have the vital interests of the data subjects and a contract as other options? I mean, if people are picking and choosing the own legal bases they want, you might as well give them a broad option and a wide set of choices. But again, it keeps getting better. I mean, let us take a moment to enjoy the absolute user interface HCI genius of this toggle, this trinary toggle. Is it yes? Is it no? Who knows? It's somewhere in the middle. It's neither yes nor no, and you can pick, and maybe then you can't return to the center. But this is obviously choice at its best. It is respecting the autonomy of the data subject. But what's absolutely gorgeous here is the way in which the user interface works with the legal genius. This person who thought, hey, what if I were MTV Pimp my website with my consent banners, and figured out that, hey, you like legal bases, so I put the legal basis on the legal basis so you can legal basis while you're legal basising. I mean, the lawyer behind this and the UX specialist who worked together are a team to be really reckoned with. And of course, you know better, much better, than to click on this part of the user interface that I've just demonstrated. Fun fact, because we can't be serious about all the things all the time, when I initially started working on the paper that goes with this presentation, I instinctively called that trinary toggle monstrosity a troggle. And in my mind, I was using a term of art, something that any HCI expert out there might recognize as being the troggle. It turns out that upon further investigation, that term did not exist, at least not in this space, even though it has been used, as you can see, in other contexts. So I now fear that one of the primary contributions I've made to posterity might be naming that atrocious UX design pattern. So, but okay, things are bad, or at the very least, some people are doing some bad things. But let's take a few steps back, right? Let's try to figure out what it is we were collectively trying to achieve with this system in the first place, and why is it that it's not working out as well as a lot of us would have liked. Now, obviously, this is not a book-length presentation, and so I'm going to give a very, very abridged introduction to the background on the topic, but hopefully that's enough background that we can all be on the same page. And just to be clear, I'm citing Belmont here, but it's just an example of a potential source, an influential one, no doubt. But there were numerous others in other languages and from other countries as well. But so basically, the core idea that we're working with that can be grounded in part, that has been grounded in medical ethics or in human subjects research, is that we want to to support respect for persons, and primarily in what concerns us here, we want to support autonomy of the data subject. The way this has been operationalized in human subjects research, notably, is through informed consent. But it's important to understand that the principle itself is not informed consent. People often take that shortcut and jump straight to that conclusion. The principle is autonomy and respect for persons. And so the idea really is, how do we operationalize that in the best way? It has worked with informed consent in other contexts, but the question is, will it work, and does it work here as well? And it turns out that there are very good reasons to doubt that it is working in this specific context, in this deployment. You know how we all enjoy complaining about how technologists like to take a solution that has been developed in one area and just sort of like lift it, cut and paste it in another area, and sort of act very puzzled when it doesn't work because it has been transplanted without its entire infrastructure, conceptual infrastructure, institutional infrastructure, everything that makes it tick. Well, what we're dealing with here is a very similar problem. Basically, the idea of informed consent has been taken from other contexts in which it works really well, but applied here without the institutional support that it requires. And so, for instance, there is no IRB that will ensure that every single potential processing is ethical before it has even been consented to. And so this, in a commercial HCI context, means that you will have unethical processing that people need to consent to. That already makes the problem much harder than in human subjects research, for instance. We're also dealing with the fact that we cannot assume that in commercial contexts, the outcome of the operation will be beneficial to the data subject or to humankind, which is a balancing test that can and does apply in research, because that's what research is done. That's why research is done. And finally, people have to consent, or at least are confronted with consent dialogues in situations where they need to get something done. They need to access these services, and that means they are not volunteers in the way that human subjects might be volunteers, often are volunteers in research contexts. So all of this introduces friction and makes it difficult to simply translate notions of informed consent over into more commercial contexts. New day, new shirt. So just because consent wants the underlying infrastructure that has made informed consent work in other contexts, once it's removed, consent is in trouble. But that doesn't mean that we can't make it work. And in fact, we need to figure out how to make it work for the cases in which it is useful. And so in this, I'm drawing and stealing quite liberally from the work of Richardson and Hartzog on pathologies of digital consent. And really the idea here is not to look at the legal requirements that exist, because sometimes they'll be good and sometimes they'll be terrible. here really the idea is to look at humans as regular people like us, with bounded rationality, who cannot make perfect decisions under any circumstance, and therefore how can we figure out ways in which we can make consent work for people in real world scenarios deployed in a commercial HCI context. And so the rules are pretty straightforward. First, it needs to be rare. If you ask people to consent all the time, you're really going to be taxing their ability to make informed decisions. So it's important that consent be infrequent. The harms from consenting, the potential downside, must be extremely vivid. This helps compensate for the fact that there is no IRB that will filter out unethical the data processing. And so we really need to make it clear that when people consent, they know what they're getting into. And finally, people must be incentivized to choose well. We're all lazy, and if we don't have a good incentive to make the right decision, if we feel like it doesn't matter, like we're helpless and we've lost control anyway, then we're not going to make decisions that actually align with our best interests and with our values and with how we would choose our data to be processed. If we had an infinite amount of rational resources and time to pick. So these are really the basic things that make consent tick. Now, I think a good idea is to look at a case in which consent works, even in cases when legal requirements such as from e-privacy or the GDPR can get in the way of consent working well in some cases. Here we have a case where it works perfectly well. And so, it's this good old, click here to sign up to our newsletter, with the checkbox being off by default. And this is something that's typically infrequent. You only see it when you create a new account, for instance. Of course, there are sites that will create pop-ups for precisely this kind of purpose. Those sites do not meet requirements for good consent, human-friendly consent. The harms of spam are pretty vivid. Everyone gets spam. Everyone knows what having a crowded mailbox looks like. And there are good incentives to choose well. People can make up their mind as to whether they're interested in receiving the newsletter or not. It's off by default, which really helps. In case you're in a hurry, you won't get it. It's always fixable in the future, and it. So people are aware of the situation, and they are mentally equipped to deal with it pretty easily. So this is a case in which consent is valid from a human perspective, and that works quite well. Of course, it still means that some of us will sign up to too many newsletters because they get excited about this new site they discovered. But again, this is something that can easily be fixed at a later time. So that was for a successful case. Now let's look at some failures. And obviously, GDPR, e-privacy, consent banners are probably everyone's most hated feature in privacy law, and they're quite obviously one of the biggest failures of European regulation when it comes to data protection, aside from Ireland. And so one of the key failures here, and that is not easily fixable with DPI guidance and requirements, as you know, DPAs keep adding tighter definitions of what valid consent is, down to what the buttons need to look like and that kind of stuff. And no matter how tight you make it, you cannot deal with the fact that every single website and app out there is going to have the same requirements, and therefore that people who navigate the broad web will encounter these very frequently, far more frequently than they can usefully deal with bounded rationality. So obviously, no matter what kind of consent dialogue you create, it will fail on this test. So that is already a problem for that approach. A second failure mode of banners is that they completely fail at conveying what harms might be entailed. Essentially, above a certain threshold, which is arguably quite low, any kind of processing requires consent, and all of that consent looks pretty much the same. So whether you are carrying out some first-party analytics that goes a little bit beyond what DPA guidance suggests is acceptable under legitimate interest, or whether you are broadcasting sensitive information to hundreds of third parties that are all of them data controllers, and all of them recognize people across their, a broad section of their online behavior. These two things will be presented to people in essentially the same way, which completely destroys any idea, any perception, any intuitive understanding of the difference in threats and harms. And so basically this idea of reusing the same UI for everything is also something that is hard to create rules for, and therefore something that will undermine this kind of approach to consent fairly rather often. And finally, the banners fail on the incentives test as well, because typically banners are completely in the way. They're completely blocking, or at least partially blocking, the experience. Often they're used as modal dialogues, or they take up a significant chunk of real estate, as we can see with this one here. The incentive for people is to get them out of the way as fast as possible, and make sure that they don't interrupt the experience. And so people's incentives are to go through them as fast as possible. And even if you enforce that, say, both buttons, the accept and reject, must be of the same color, the same size, whatever the latest guidance and requirements are, even with that, there will always be a preference in terms of focus, which one is on the right, which one appears closest to something else. There's always a way in terms of UI to give one preference over the other. You might decrease the consent rate with stricter guidelines, but you'll never get it to the level at which we can say that people are giving any kind of usefully informed consent and making real proper decisions when they're dealing with something that they just want to get rid of as fast as possible. Now, there is nothing in e-privacy or in the GDPR that says that you must use a banner. So there's a real sense in which it might not be the regulation's fault if we see these terrible implementations. But at the same time, when regulating a system at this kind of scale, it's very important to think adversarially, to build it in such a way that the people who want to work around it, who want to break it, won't be able to do so. And that is where consent becomes particularly problematic. I often hear people say things like, "Oh, consent is wonderful. It's only that marketers or ad tech have broken it." But if it's breakable, it's not a very good defense. It's not a very good data protection mechanism. It's a bit like saying, "Oh, I encrypted everything with ROT13," which is, look it up. It's not a great encryption scheme, but those evil people broke my encryption scheme. And so I've looked at a few issues with banners, but the issues keep going, and it's hard to see how to fix all of them at the kind of scale that we're dealing with. One suggested fix for issues that have been seen with consent banners that the DPB gives some credibility to, and that I've often seen lawyers get quite excited about, is layered consent. Layered consent is essentially the idea that if you have too much information in order to show the data subject in order to get informed consent, then you should solve that by showing them less information and requiring of them that they dig more deeply into the user interface in order to figure out what they're consenting to. Perhaps one of the most difficult part of getting consent right is that architecturally it relies on the party that has the greatest incentive to present its work in the nicest light, to tell the truth and to provide people with the means to decide. That doesn't work, because you can force people to say some things, but you can't always force them to present things in the way that is the most relevant to the data subject. And that can be seen quite clearly with the silent part in this statement, right? The initial half, the first half of the sentence, could credibly exhaust the topic, and it's quite typical of the kind of description of data processing that one might see. But without telling people what is being optimized for and how exactly, then you're not exactly telling data subjects what is going on and what the potential risks and harms are here. And so it's very difficult to get that second half surfaced without either drowning it in technical detail or rendering it, making it read like something harmless when it really isn't. More generally, I think that it's important that we do not turn consent on the internet into an arms race, because what will happen is, if we keep tightening requirements without taking into account the way in which those who want to circumvent those requirements will react, we'll end up in a situation in which the people who suffer are the data subjects, and we get no data protection results from it. And it's really important to understand that statistics are very powerful at the kind of scale that we are dealing with. And if we mindlessly create new requirements, as has been happening over the past decade or so, we'll basically create a system in which the rich get richer. Those who are the most determined in working around user autonomy will succeed, and so basically the worst players will be the most successful. That is not a good outcome by any means, and so we need to be extremely careful in how we specify what can be consented to and what should be consentable. And last but not at all least, in this list of issues with consent to data processing in the wild, is the fact that privacy is inherently collective. We've grown used to thinking about it purely in individualistic terms, and consent is a hyper individualistic solution to the problems that we're facing. But really, at the end of the day, information is inherently relational. That is what information is. And when we learn something about one person, because we are statistically similar, especially at the kind of scales that we are dealing with, then we don't learn something about just that person. We learn something about everyone who is sort of similar to that person. And in fact, if, for instance, you are quite similar to me and you consent to being fully profiled and I don't, well, the fact that we read the same stuff means that I can be targeted contextually with very high precision, potentially in discriminatory ways or sensitive ways, simply because you agreed to data processing, and the targeting works whether or not I agree as well. And so we do need to take this collective dimension into account. Otherwise, none of this privacy, none of this data governance works. But we absolutely cannot do that with consent. So consent should really be limited to things that are predominantly individual, and there aren't that many. At this point, it's tempting to believe that there's nothing that we can do, that everything is lost. that basically consent, because of its transplantation issues, its HCI issues, its collective issues, cannot be fixed, even with far stricter and smarter guidance and enforcement. And so, should we just give up? And I don't think that's the case. I think there is a path forward. I think there are things that we can do to make the situation significantly better, but they won't be these solutions will not be easy, and they will not be problem free, but they're still very much worth exploring, because this is a complicated space and it's the entire future of data that we are talking about, and therefore it's worth getting right, putting the energy into it that it requires. In doing so, the first thing that we absolutely need to acknowledge is that this is difficult. These are entirely new problems in this space, and this is a story that I like to tell, because I think it adds some perspective to the issues that we're facing. When homes started to be electrified, connected to the electric grid in the 19th century, uh, a lot of people felt that they could just tap into the grid directly, just like hook their houses up without paying the electrical company. And from today's perspective, in 2022, this seems unthinkable, or at least it seems pretty clear to us that constitutes theft. Well, that was not at all obvious to people back then. In fact, the German Supreme Court at the time decided that this was not theft, because theft is when you take an object, an asset from someone. So, if there's a chair and you take it without permission, that is theft. But electricity doesn't really fit that definition. And in fact, this topic remained contested well into the 20th century, and it's only I think the last case to die out in this domain was in the 70s in the New York Supreme Court. And so it took a long time for people to understand how to approach electricity as an asset, as something that may be stolen or may be processed differently. And data is even worse. I mean, electricity is somewhat abstract, but data is completely weird as assets go. And it's going to take a long time for us to figure it out. It's going to take a lot of thinking, and once again, that's all the more reason not to offload that privacy labor, that thinking onto people, and just like dump them with like consent requirements that they cannot possibly be equipped to handle. We need to do much better. A first step in doing better is to broaden the angle somewhat. And so essentially, privacy is a subset of data governance. It's the subset that relates to data that is about people or that impact people. And so as soon as we start looking at governance, governance is rule systems, and governance relies on institutional mechanisms. That is where it happens. And these institutional mechanisms can decide these rules, they can modify these rules, enforce them, and essentially create ways and that can be like highly specific for actors to be constrained or empowered in a great variety of ways. And there's a whole toolbox of governance systems, governance, institutional arrangements out there that we can draw inspiration from in order to help us with this data protection quandary. Perhaps the most common mistake that we make in thinking about these problems is to approach the situation as if only state actors or companies could solve it. And this tends to turn us into powerless people who can only be on the sidelines, maybe on Twitter, complaining about lack of enforcement or bad regulation on one hand, and bad behavior from companies that seem to be above the law on the other. Neither of these are good extremes. It doesn't mean that they cannot help, they should, participate in solving the problem, but we can do better. We can create our own institutions, and figure out ways that we develop institutional arrangements in which some of us can participate, some of us can represent others, and through that build collective data governance that might be highly specific to an industry, to a topic, but more importantly is negotiated between different stakeholders. You don't want something where just one type of stakeholder decides for everyone else how data should be processed. That is what happened 20 years ago with all the ad choices systems that never worked and never delivered anything of any value. But if we bring together and we create the conditions that multiple kinds of stakeholders will want to negotiate together to find common ground, then we can start building governance systems that have credibility and that have some degree of agility, such that they can evolve over time to match our needs as people. If you're listening to this thinking that what I'm talking about would likely make things a lot more complex than they are today, then you're not entirely wrong. The situation we have with data processing on the internet is complex, getting it right is difficult, and applying overly simplistic solutions like consent the way it has been done so far is unlikely to produce any kind of positive outcome for anyone. And I like to use this diagram here because this shows the complex interplay of different actors that are involved in forestry management. And it shows that if you develop institutional capacity, if you build your ability, your collective governance capabilities, then you can create a situation in which various contexts overlap and nest and intermesh in ways that create a robust governance framework, a robust governance interplay of different actors and different systems. And this creates capacity for a successful management of difficult real world problems. And essentially, this idea that we can collectively improve things and that we can create a thicket of governance mechanisms that might be industry specific or topic specific, area specific, and that will are designed to support data subjects first and foremost, is what is being proposed in this new W3C document that is being written by the TAG, the Technical Architecture Group, which is sort of the umbrella group for principled approaches to technology. And basically, it is trying to frame a system such that data governance can emerge from various areas of the web and really be built in ways that support people. This document itself does not define these governance principles, but it does offer a set of values, a set of foundational rules that should be applied across the web in order to improve privacy for everyone there. I'm not going to go through this document in extreme detail. It's not the topic that brings us together today. But I'm going to look at a few high-level principles and high-level approaches that it has taken, because these are the ideas that frame the way in which we are considering how privacy should be managed on the web, and basically give a foundation to more specific, more contextual, more refined ways of approaching the issue. And so, one of the core tenets of this document is that concentrations of data are concentrations of power, and in order to avoid asymmetries of power, we need to do everything possible to avoid concentrations of information. And so, the idea is that really we are trying to protect people from excessive concentration of information in anyone's single hands. Another core focus of this document is really centered on individual autonomy. And something that some people do find counterintuitive is that if you want autonomy, then you cannot want consent, at least not in the way in which it is deployed today. Really relying excessively on consent cannot possibly respect people's autonomy because it taxes bounded rationality way too much to be autonomy enhancing. And so it limits people's agency. And it is also disrespectful of people to offload privacy labor, which is the work that one has to do in order to ensure that a given type of data processing is respectful of people's dignity. It is disrespectful to offload that systematically to data subjects by asking them to consent. And so really, this document does not reject consent at all. It supports it where it works, but it necessarily has to restrict it to certain specific cases in which it is actually autonomy enhancing. Of course, a key assumption behind a lot of these considerations is that data processing can be used for good and regularly will be used for good. If we believe that a certain type of data processing cannot be used for good or will almost certainly not be used for good, the solution to that situation is not to require it to be consented. You don't want people to consent to bad things. That's crazy. And you know, because privacy is collective, if a few people consent to something bad, it could affect all of us. And therefore, the solution for bad data processing, harmful data processing, is bans. It's outright bans, and not procedural means to make it legitimate. And so, for instance, the DSA has some provisions going in that direction, and that's encouraging, even though we probably need quite a few more in the same vein. And so, so the document, the tax privacy principles, does consider privacy to be a collective issue, an issue for collective governance, and that requires collective solutions and not hyper individualistic approaches like consent. Also, one thing that's particularly important to take into account here is the idea that privacy is context specific. That is something that you will be familiar with from Helen Nissenbaum's work, but that is also brought forward in the Governing Knowledge Commons framework that has a book about privacy that has collective privacy, contextual privacy in an institutional setting with an institutional rules-based approach. And so this is what we hope to work towards at the web level. One example of this kind of arrangement of collective governance is the Garuda proposal, which I made a short while ago, and that is still being discussed. I'm not claiming that this is an ideal proposal or that it will eventually see the light of day, but I mean it as an example of the kind of arrangement and discussion and governance model that we can adopt in order to support better privacy while supporting use cases of data processing that are valuable. And so here the idea, which might sound crazy to a few people, is to make digital advertising trustworthy, or to make trustworthy digital advertising possible. And the idea behind Garuda is to produce a governance model for a trusted server, and by trusted I mean by all parties. So for instance, by people, it has to be one component, but also by publishers and by ad buyers. And the idea is to make this trustworthy using a governance model that can represent all parties around the table and make sure that they cannot do anything without reaching consensus on what is good. And so essentially this trusted server makes guarantees of anonymity that really protect people from being recognized as they browse the web, while still enabling a number of useful advertising use cases. And so the idea here is to introduce this sort of third party that everyone can trust and that is managed under a collective governance model. So instead of offloading the difficult work of figuring out what is happening at the advertising level, even in cases that are strongly privacy preserving, that provide really credible guarantees of anonymity. Instead of offloading that to people, which is unfair in any circumstance, the idea here is that representatives of the people, which are selected in a specific way. And again, I'm not claiming that this is necessarily perfect. It's just an example of the model. Have to argue and reach consensus with other parties, and no party can dominate on its own. And even alliances are such that they can only go so far without a supermajority of all constituencies. The idea is really to enforce balance between different interests, such that you get a result that might not be ideal for anyone, but that is good for everyone. And this can be sustained through an evolving governance model over time, and of course should be transparent, should be guided in public, and this can be reproduced if it is successful across different contexts and in different areas, such that we can start building this polycentric overlapping set of governance models that really help guard data, protect people, but still make useful contributions based on data processing in the world. Of this talk about creating our own institutions and collectively governing privacy for better outcomes might sound fun, but perhaps a bit difficult to operationalize. And it's certainly true that not everything can be done simply by snapping our fingers. But we shouldn't forget that existing legal infrastructure, for instance, in Europe, can actually already support some of this work. So, of course, there's Articles 40 and 41 on codes of conduct that could help provide some degree of support for this kind of work. But even good old consent itself could actually be deployed in a way that supports collective governance. Using systems like ADPC, the Advanced Data Protection Control Protocol, we could have a system where decisions as to what is appropriate, what should be consented to, are made collectively, and then people simply have their browsers send the right signal to match that kind of the decision made collectively by delegating the power to consent to another party and implementing it through this protocol. So this really helps show how automated signals can really come to the rescue of limits imposed by bounded rationality by automating things in favor of data subjects. One of the greatest inequalities in a digital context that is very rarely discussed is the asymmetry of automation. People who process the companies and entities that process data do so in an automated fashion across the board, whereas people are made to make decisions manually and to set preferences and to make manual individual decisions every time. This is always going to be unfair, and so the idea that we can use automation on the data subject side is really powerful, and using that to implement decisions made collectively and rendered binding by existing legal bases is, I think, one of the keys to figuring out how to solve this big mess that we have right now. And with this, I want to thank you for your time, thank you for your attention, and we should normally have some time left for questions. So, fire away. And thanks again.